6th District Court of Appeal. I'm Judge Keith White and have the honor of serving as the presiding judge today. Serving with me today on my right is Judge Ganem, and on my left is Judge Lambert, who's graciously been helping us for almost a year now. I do want to remind you a couple of housekeeping matters. One, the proceedings here today are being both video and audio recorded. I just want to make you aware of that. And then also, please make sure phones or any other electronic devices that beep, vibrate, play music, or make other kind of noise that might disturb the proceedings, please make sure they are off. Thank you. All right, our first case today is 2023-2617, Beacon Park Phase 1 Homeowners Association v. D.R. Horton, Inc., etc. Council ready to proceed? Appellee? All right, whenever you're ready.
Good morning,
Council. How much would you like to reserve? How much time for rebuttal?
5 minutes, please.
5 minutes, okay.
Good morning, Your Honors. May it please the court. My name is Samuel Alexander, and I represent the appellant in this case, Beacon Park. This court should reverse and remand for two principal reasons. First, the trial court erred in ruling that Beacon Park had notice of defects in the 2011 new stucco before those defects even existed. Second, the trial court erred in ruling that the removal and replacement of an entire building component, the 2009 old stucco, and its replacement with a new building component, the 2009 new stucco, requiring new plans, new permits, and new approvals, was a repair to completed work within the scope of the prior permit.
Mr. Alexander, I'd like to go back to the beginning and look at paragraph 1 of your complaint. It reads, "This is an action for damages arising from the negligent and defective development, design, construction, repair, and sale of condominiums and common elements at the Beacon Park Phase 1 community in Orlando, Florida, the townhomes." Just reading paragraph 1, which is incorporated by reference in all the causes of action. Why doesn't that tell us that for purposes of 9511, the relevant improvement upon which this action is founded is the townhomes, and that the work at issue here, the repair, is repair to completed work of the townhomes?
I think that there are two responses to that. The first is that there's a difference between a repair and kind of the common sense use of the word repair and repair in the statutory sense of the word repair. So, for example, a new stucco installation or a new roof might be a repair to a building, but it's not a repair to the old roof, or it's not a repair to the old stucco installation. The second response is that the issues were narrowed considerably by the time that summary judgment occurred, and the trial court's judgment notes that the parties had Beacon Park had conceded that it was only suing on the new stucco work by the time they got to summary judgment. All other issues had been resolved. So the only defects remaining were the defects contained in the 2011.
But when this case was filed in 2020, the safe harbor was in the statute of limitations, the repair safe harbor. And the language of the complaint talks about the action as being an action regarding all the townhomes, and uses that word repair and even defines the work that's at issue in this case in the complaint as, capital R, repairs. Now I understand when we get to summary judgment, the owner calls this new work, but we haven't seen whatever stipulation is referred to by the parties. Was there some stipulation that it was not a repair, that it was new work?
No, there's not a stipulation that it wasn't a repair, but there's a stipulation that the suit only revolved around defects contained within the 2011 new stucco work. And I think there's a difference between the word repair as it's commonly used and repair as it's used in the term the statute for the purpose of the statute of limitations. And so it's kind of like the difference between, is a tomato a vegetable or a fruit? In common parlance, maybe it's a vegetable, but botanically it's a fruit. In this case, the repair may be a repair in common parlance, but under the statute, under the 2019 amendment, a repair is limited to when you have completed work that was built pursuant to a permit and a COO is issued, and you correct defects to that completed work and then sue on that completed work, the correction of defects does not extend the statute of limitations.
But didn't Beacon Park here sue on the completed work? I mean, that's what it says in paragraph 1 of the complaint. This is about the design, construction, planning, repair, and sale. It's all of it in this case.
Well, and there was an amended complaint.
Well, I was reading from the amendment.
Okay. But again, we would just reiterate, by the time it got to summary judgment, the suit solely revolved around defects within the 2011 new stucco work. And there was no repair to the 2009 old stucco work. It was completely removed. All the defects that existed, so they argued that there was notice of defects within the building envelope or the building writ large. But any defects that possibly existed within the 2009 old stucco were entirely removed and replaced by the 2011 new stucco, which contained new and different defects.
How do we know that from this record?
Because there is a stipulation below. The 2009 old stucco was entirely removed all the way down to the wood framing of the building. And so that the 2009 old stucco is what D.R. Horton told Beacon Park, hey, there's some performance issues with the stucco. We're going to replace it. To this day, we don't know what those issues were. Nobody in the record can say. But the old stucco was entirely removed down to the wood framing. The parties have stipulated to that. Mr. Alvelli, their corporate representative, testified that none of the 2009 old stucco remained. It was entirely reflashed from the ground up, or from the second story up with brand new stucco. So with new permits and new approvals. So it's really like a new roof. I think we can analogize it to a roof. If you replace your roof with a new roof and you strip the entire old roof off and you get new permits for a new roof and the old roof is stripped off down to the wood framing and there's new flashing and an entire new roof is put on, when does the statute of limitations start to run for defects contained within that new roof?
Wouldn't it make a difference if that new roof was put on to a recently completed project that's still, within a couple of years versus a new roof 20 years down the road when it's just being replaced because it's old and due for a replacement?
The statute doesn't make any sort of differentiation like that. So under D.R. Horton in the trial court's reading, a new roof on a building that's older than 10 years could simply never be sued on, because a new roof is just a repair to a completed structure that was built pursuant to permits and a COO is issued. And if you replace the roof, you're really just correcting a defect in the building envelope. And so it doesn't extend the statute of limitations from whenever the building was built, unless, as they say in their answer brief, unless the building is torn down. And we don't think that section 95.113C.
Let me ask, if we're talking about the new work, what is your summary judgment evidence in the record as to when those latent defects manifested?
So the only real evidence in the record are the two expert reports, the 2020 report and the 2021 report. 2020 report states that there was an expert that was hired to review the building. It reviewed the outside of the building. It didn't do any destructive testing and said, it looks to us like there are possibly issues with the stucco work. There's a lack of drainage.
And that report predates the filing of the lawsuit.
Yes.
The 2021 report, that would seem somewhat chronologically illogical that you became aware of the defects after you had filed suit.
Well, the 2021 report led to the amended complaint.
Okay, but all right. So your view then is the summary judgment evidence was that the statute of limitations began running at the time of the 2020 expert witness report, and then you therefore had 4 years from that date to file your action, which you did within a matter of months.
Yes.
What is the date? Well, let me rephrase it. Other than what appears to be what the trial court bought or agreed to, or whatever term you want to use, that the defects manifested themselves in 2011 when Horton came in and said, I'm going to give you guys all new stucco, or I'm going to replace the stucco, or whatever term. I mean, I know how we use those terms today is of importance. Is there any other evidence from their side as to when they believe, any other summary as to when they believe that the defect in the new work manifested?
No, they put all their eggs into the 2011 replacement basket. which is that they have two pieces of evidence that they rely on. One is that in 2011, they told Beacon Park there are performance issues with the old stucco, so we're going to replace it, if you don't mind. And the other is that the replacement itself acted as a form of open and obvious repair, giving notice of defects.
So if I understand their position buttressed by the findings of the trial court. So in 2000, I think 2012 was when they say April 24, 2012 was when we finished everything in our remediation.
Mhm.
So in their view, the meter started running, the statute of limitations meter started running in 2011. When they
Yes.
came to you.
Yes,
All right, and they came to you guys and said, hey, we need to fix this.
Mhm.
So they would have, under their view, then you guys would have, you Beacon would have needed to sue by sometime in 2015 on any defects to the new work, because the old work's gone.
correct.
I mean, the old stucco's gone. Irrespective of whether there's anything at all that remotely showed to you that there was some problem with the new work.
Precisely.
That's the interpretation that I get from the final judgment that's entered adversely to you guys.
That's correct, yes.
And that's logically consistent with the statute, apparently.
No,
Well, according to their side,
Yes.
according to the trial judge.
we would disagree with that. We think that
Well, yeah, I would think so.
we think that the statute doesn't intend for there to be the possibility of.
Well, I'm just trying to envision saying, okay, you know, they're Deacon's listening to Sam Alexander, and they say, we got to file suit. Horton gets the lawsuit and they say, hey, what's the problem with the work we did? Nothing.
We don't know.
We have any defects. Well, why you sued us? Because the statute might run and there might be something comes down the road. Is my logical question the proper extrapolation of the posture the case has placed you in?
Yes,
All right.
Counsel,
Sure.
you made you referred to the D.R. Hortons coming to Beacon Park in 2011 saying there's a performance issue with the stucco. We'd like to replace it if you don't mind. But Beacon Park wasn't, merely a passenger at that point. It was your townhomes. You could have said no. You could have said, why do you want to replace it? What's wrong with it? What are the defects that you're fixing? Now, the record doesn't show us whether or not any of that happened. But we also can see from the record that you have your expert report refers to ongoing water intrusion issues. It refers to the collection of surveys or questionnaires from homeowners. And if I go back to the trial court transcript from the hearing, the trial court judge, did understand your theory and said, so what you're saying is that there was a latent defect that didn't manifest in, for example, the trial court used 2016. And so you filed suit in 2020, so you were timely. And I understand you weren't trial counsel, but trial counsel's response was, well, nobody knows. There's no evidence when we did discover there was a problem. So how can we sit here and have with any confidence and say there wasn't a discovery of whatever the defect was within 4 years of 2011 or 2012?
I think the response to that is twofold. First, below and on appeal until recently, there's been no question that the burden was on D.R. Horton to show that there was actual or constructive notice more than 4 years before the suit was filed. So Beacon Park asserted in its summary judgment response below that D.R. Horton had the burden of proof. D.R. Horton never pushed back against that. So the posture of the case was, well, we have this expert report from 2020, but no, we don't precisely know when these defects manifested. But it was D.R. Horton's burden to show that. There's been a question on appeal over who has the burden. We've got some responses to that if you'd like to hear them. But I think the other evidentiary fact that we have to rely on is the 2020 and 2021 reports themselves are evidence. We cited the value case from the 11th Circuit Court of Appeal, are evidence themselves that Beacon Park did not know that there were actionable defects or what caused the actionable defects, and that they were exercising due diligence.
Help me factually from the record to connect the existence of the reports and whatever those reports say, and when Beacon Park, knew or with the exercise of reasonable diligence should have known there was a problem.
So I think the 2020 report, there's not much indication, but the 2020 report doesn't. One thing that we do know is the 2020 report does not mention any water intrusion at all. It's the 2021 report that mentions water intrusion. So one thing that a jury could reasonably infer from that is that there was no water intrusion prior to 2021 because the 2020 report didn't mention it. And that Beacon Park didn't know about any possible defects until 2020. And that there was
What prompted the 2020 analysis?
there's actually no evidence in the record as to what prompted.
Beacon Park just said, hey, we're gonna have somebody look at stucco in 2020 and tell us what they think?
As far as we know, yes.
Council, would you agree if it's your burden that lack of evidence in the record would support from?
No, because we believe that we've met the burden by arguing in the summary judgment response that the 2020 and 2021 expert reports were evidence that they did not and should not have known of actionable defects.
Let me ask you about under the new summary judgment rule. This statute of limitations raised by Horton still affirmative defense. They still have to make a prima facie showing of that before you have any burden to put on counter summary judgment evidence. For example, plaintiff sues on a car accident and says, well, you hit me last year and I'm injured and I'm filing suit. Defendant raises a statute of limitations defense. You say, well, let's say it happened now, it's 2 years now. Okay. There's no prima facie showing that the statute of limitations defense would apply in that circumstance, and then you would not have the obligation to put on any counter evidence. And is there some analogy here if they're relying on the notice being to the 2011 defect, of which the defect is not what the basis of the claim is? They really haven't made a prima facie showing of the applicability of their statute of limitations defense, which did not require then you to come forward, despite the verbiage of the summary judgment rule now, with counter evidence to show when you may have discovered the defect with due diligence. I don't think I could probably repeat that.
That's correct.
Said,
yes, we agree completely. And especially since it's stipulated that the defects in this case were latent. And so there's not an argument that, well, the work was done in 2011. So that's a prima facie case that the statute of limitations started running because there's a stipulation the defects are latent.
Council, you are into your rebuttal time.
I'll reserve my time. Thank you.
Thanks. Council.
Judge White has just had a primer on working the clock today. We'll see how he does on the second side.
We will.
May it please the court. I'm Lindsay Lawton, and with Michael Brownlee, I represent DR Horton. This court should affirm based on the simple and correct analysis the trial court provided, and it should reject Beacon Park's effort to evade the straightforward analysis by creating a distinction between new work and old work that is directly contrary to the 2018 amendment to the statute of limitations. I'll start with the main analysis that applies to this case and then address Beacon Park's new work / old work argument. So the main analysis is that lawsuits based on construction defects are subject to a 4-year statute of limitations. There's an exception for latent defects, and when a lawsuit involves a latent defect, it must be brought within 4 years of the time the defect is discovered or should have been discovered with the exercise of due diligence.
Ms. Lawton, let me ask you, suppose we had a clean slate here and Beacon Park was happy with the construction of the townhomes. There were no issues other than DR Horton coming in and saying, there's a problem with the stucco, we'd like to fix it. And they do that. And then, a few years later, Beacon Park just sues DR Horton based solely on defects in that new stucco work. I mean, it's undisputed there was significant stucco work done. Could they have based a lawsuit just on that stucco work? And by doing that, fit it into 9511, it being that the stucco work itself being the improvement on which the action was founded, and avoid this repair issue altogether?
No, they couldn't, because the repair issue is central to the analysis. The concept of new work is foreign to the statute. Under the statute, repair work is indistinguishable from the original work. And if I understand your hypothetical correctly, then whatever DR Horton did would have been repair work. Are you suggesting that this would have been a situation where DR Horton did not tell them that there were performance issues?
I'm just trying to fit the statute to the situation that we have. It is clear that this was significant work. Your colleague analogizes it to a new roof, for example. And it's just hard to fathom that that coming in and replacing the entire second story envelope, for example, still ties into the original construction as if, as if whatever defect existed in 2009 when construction was completed wasn't completely ameliorated by this repair. So I'm just trying to understand if they could have avoided this problem that we're having between new work and old work and repair, if they'd have just sued on those on that new stucco work by itself, if we would still necessarily have to look at it in the broader context that it was repairs to completed work that, that was just completed 2 years before.
I understand. Yet, changing the allegations of the complaint to not refer to the original construction would not have made a difference, because the facts of the case will be the same, that the work being sued over was repair work. And I understand, there's some concern that this was a large scale project, but the statute does not distinguish between major repairs and minor repairs.
Let me then see if I understand this chronology then that you're espousing. So let me change the dates. So 2009, they do this work. Horton finishes their work. So 2 days before 4 years of their completion, they come in and they replace all the stucco. They take out the bad stucco and put in the new stucco. And everybody's happy. Beacon says, well, that's very nice of you all to do that. And Horton says, well, we're just good guys. So they do all that.
Mhm.
So if I'm understanding what you're saying now, correct me if I'm wrong, because, they now have 2 days under my hypothetical to file suit about any defect that shows up post new work. Am I accurate in what you're saying?
I don't think that would be the case,
Why
because
not?
there would be a new event that occurred that gave notice of a latent defect.
Well, what's the new, but under your scenario, the new event is Horton, taking your scenario and my hypothetical, the new event is instead of 2011, Horton came in 2013 and said, hey, bad stucco we put on all these buildings. We're going to take all the bad stucco off and put all good stucco in. We got it from new people. Good work, good job. We're putting the new stucco on and you're gonna be good as new. And who as a homeowner, as a Beacon would say, well, hey, that's awful nice of you. Thank you. And you go do that.
So you're
And-
saying, there was the original remediation, and then there was another one a few years later in the hypothetical?
Just like here, it's 2009 to 2011. And you guys are saying, you guys, Beacon, are on notice as of 2011, there's a problem. Therefore, if I read the judge's order, you should have filed suit by 2015. You didn't, so you lose. Okay, so but in my scenario, taking it to the illogical extreme, you come in 2013, 2 days before the meter's running. The statute of limitations meter, for lack of a better term, lack of a better legal term. And you do all the work and you're done. You're done 2 days before the 4 years ran on the initial work. Basically, if I'm understanding consistent with the position here, they had 2 days to file suit so that they're not barred by the statute of limitations if 2 months later that stucco falls apart for whatever reason, latent defects, and it's gone. Isn't that just the same case you have here, except I've changed the bar as to when it happened? And that's what you say is the intent of the statute. The legislature said that's a perfectly fine thing to happen.
No, Your Honor, that is not our argument. Our argument is not that they had to file as soon as the repair work was done. Our argument is that the repair work put them on notice of a potential latent defect and required them to exercise due diligence, and therefore
In
gave
those
them
2 days, in my 2 days.
No, they had 4 years from the discovery of a latent defect.
Well, but the latent defect. Okay. I won't use your time. Go ahead. I'm sorry. Go ahead.
And an important thing to remember is not just that the repair work did not start a new statute of limitations under the plain language of the 2018 amendment, but also that under any scenario, Beacon Park had the burden to present evidence of when it discovered the latent defects, because that is an exception to the statute of limitations.
And isn't their position, if I'm understanding your opponent, their position is we became aware of the latent defect in the new stucco in August in 2020 when we got the report. Is there anything that predates that says that they became aware of a problem? That's why they engaged somebody to do a report.
There's evidence that predates that is shows that they knew or should have known of a latent defect. And that is the 2011 and 2012 work that showed there was a problem with the building envelope. And so, I'm sorry.
With the old work, right? So they took the old work out. So we're gonna,
Well,
I'm trying to, as an old trial judge, I'm sitting here saying, okay, I'm looking at a jury saying, okay, here's the statute of limitations factual, because they want this to be a factual dispute for the jury. The jury would all scratch their heads and say, well, but they took all the old stuff down and they think the new stuff's bad. And you're telling me as Horton that, no, you got to go back to the time we put the bad stuff in, even though you took it all out. And you guys need to rule in my favor, enter, statute of limitations. There's many times I've read jury instructions to juries. They look at, you had the dog gets the turn of their head like, what you talking about? And I'm seems like I'd be following the same turn of the head here on if I was instructing in this case like that.
well, the situation here is not that the original construction was taken down. There was an original construction and there was a repair to it,
Yeah,
to the envelope.
you didn't bulldoze the house down, but I mean, isn't there suit about the stucco? Isn't it?
It is about the stucco and sealants and other components of the building envelope. They talk about the stucco
How
a
they
lot.
sealed the stucco to the house.
Right, but all of that is a part of the building envelope that all works together as a system. And in 2011, Beacon Park was notified that there were performance issues with that system, the building envelope.
Was there record evidence that they were complaining to Horton about problems, or did Horton just proactively say, we're, countrywide, we're gonna make these changes because this turned out to be bad stucco that we installed?
The record evidence is that DR Horton came to them and said, we are concerned about performance issues and we'd like to repair it for you. And they accepted that. And DR Horton went ahead and did it, and they sat silent
So
for
they
8
weren't
years after
complaining.
that.
In other words, they weren't complaining. They're saying, man, you guys just built this and all that, we're having problems. You got your side the Horton, not you, but the Horton came to them and said, hey,
That's right.
okay.
And then did the work, and Beacon Park sat silent for 8 years and has provided no explanation for why it suddenly in 2020 decided to do an inspection. So once you get to summary judgment, we filed a motion for summary judgment. We said the statute of limitations has run. And the only evidence everybody presented their evidence on the statute of limitations. And
Well,
the
is it
only
your
evidence,
burden? Whose burden to show that so I understand that, that they discovered or should have discovered this latent defect. So isn't it your burden to show when they should have discovered the latent? In other words, you guys should have discovered this well before 2016. And when you filed in 2020, you're too late. So I win. Wasn't it your burden to show that they should have discovered it with due diligence before 2016, the 4 years?
it was our burden to show that the statute of limitations had run. And then under the Richardson case that was cited in the supplemental briefing order, they had the burden to come back and say, no, it was a latent defect. And here's when we discovered it or should have discovered
Did the
it.
first DCA shift their view about that in a later non-construction case?
They did not, Your Honor.
You sure?
Yes. That case is not about
Glass versus camera?
Glass versus Cameron.
Camera.
I thought you were referring to the Caudill case
I
cited.
don't care about that one. No,
You'll have to remind me about the glass.
well, it wasn't in the construction context, but they were talking about, it was in the medical malpractice context where you have to, you may not know that you've been the victim of medical malpractice and you have 2 years to bring your claim when you discovered it or should have discovered it with the exercise of due diligence. I mean, if the defendant, doctor, hospital raises that, it's their burden, according to a later first DCA case, post Richardson, to basically say, you plaintiff should have discovered this well before well before 2 years before you sued us. The plaintiff doesn't have the burden to affirmatively show why they weren't diligent. I mean, obviously, if there's summary judgment evidence that meets the threshold of prima facie, then the plaintiff puts on counter summary judgment. But it seems the first DCA, I will admit it's in the context of med mal, but it's the same theory of discovering the defect you knew or should have known. It's not like a car accident. You hit me. I know you hit me. This is the day it starts running. You as a doctor leave the sponge in my stomach. I don't know about that right away. Hope I wouldn't think, but maybe I do, but I don't, but it still is a grayer area and it's your burden as the doctor. I don't understand why. And it seems like you traveled under that until we interjected the Richardson case by order here. Isn't that fair?
Not exactly, Your Honor.
No, okay.
So there's a
I
lot,
must be reading the wrong.
there's a lot to respond to there. So as far as the glass case,
Go ahead.
it's, as you pointed out, it's a medical malpractice case. Every statute of limitations requires knew or should have known. And a lot of times it is the burden of the defendant to establish that fact. But under the statute that we have here, it is expressly stated as an exception when the latent defect was discovered or should have been discovered. So that would distinguish the glass case. Also, in the briefing, in the initial brief, I pointed out the lack of evidence on their side of when the latent defect was supposedly discovered.
Counsel, you assert that it was the D.R. Horton basically putting Beacon Park on notice that there is a defect in the envelope by fixing it for free, basically. And so it's your position, and as you put forward in your summary judgment paper, that, you've established it is a latent defect, but they've been on notice of it since we began the repairs in 2011. What would Beacon Park then have to show in response to that to avoid your affirmative defense? Because you already identified it as a latent defect and already say they're on notice of it. They said, well, no, we weren't. We don't know anything about construction. We're lay homeowners and board members. So what else could they have shown to avoid your affirmative defense, or at least create an issue of fact for the jury?
They could have shown what happened that caused them to ask for that inspection to begin with. And here, when we moved for summary judgment and we said the statute of limitations has run, we presented all the evidence that existed in the record on that point. And when you look at all that evidence, there is one fact that tells you what possibly could have led to them to ask for that inspection. And that is the 2011-2012 work. If there was something else, then the burden shifted to Beacon Park to tell the trial court what it was. And that's true regardless of who.
So in 2020, they decided that we need to hire somebody to look at defects that occurred in the stucco work that was removed and, taken to the dump or whatever happens to old stucco in 2011. And I would think that they would have engaged the new engineers or stucco people to say, look at the stuff that's now on here. How are we doing? We want to be proactive. We want to be diligent. We've read 95.113C. We want to make sure we do that.
So of course
I'm trying to understand what it is. I would seem if I'm an engineer or a stucco person, so why do you want me to tell you if the stucco that's gone was bad or was defective?
The inspection was of the repair work.
Sure, the new ones, the new
Right.
stuff, the brand new stuff.
Yes, and the reason given in the inspection report for the inspection was a history of performance issues, which is exactly the language that is used in the record regarding the notice that D.R. Horton provided in 2011 and 2012. It also refers to water intrusion, but again, Beacon Park never said when this water intrusion occurred. And the absence of evidence on this fact is dispositive regardless of who bears the burden, because we certainly made a prima facie case by saying statute of limitations has run, here's the evidence on the issue.
But they're saying now that we became aware of the latent defect in 2020 when we got the report. And that's when we believe the statute ran and that we acted with due diligence, and that's how we first found it. There was nothing that came up before that. Apparently, because there's nothing of the record, I'll grant you that. So we became aware of it at that time. Why is that not material evidence to defeat your argument that apparently your side's position is that the meter started running in 2011? Am I accurate with that? The statute of
Yes,
limitations.
or at the latest in 2012 at the end of
April 24, 2012, when we finished everything and we packed up all our stuff, Orton left the premises, did our work. Okay, so at that point, they had until April 24 of 2000, Beacon, in your view, till April 24 of 2016 to do something.
Yes. To conduct an inspection and exercise due diligence to bring a lawsuit if there was a ground for one.
Okay, and so if they did that and there was nothing there, or if nobody made any complaints, we got no problems, everybody's happy, what a wonderful bunch Horton is, they fixed everything for us proactively, we didn't even ask them.
Mhm.
And so we had no reason to file suit. I would think if I was a trial judge, I'd sit there and say, well, why did you sue? If there's nothing wrong with what they did. Just to protect ourselves in case something goes wrong down the road. And I think I would probably think that means that they would lose at that time.
That's
But later on, but now they do find something in 2020, and they say, this is when it first manifested itself. And so we've thrown the gauntlet down. We filed suit and you guys come in, oh, no. It's your burden to show they should have, whatever is wrong in 2020. You should have been able to see it back before that if you had done anything, but you didn't. Therefore, we went into the statute of limitations. I mean, isn't that your case?
Our case is that you should have exercised due diligence to to inspect whether there was a defect when they were on notice of performance issues. And the rest of the case is just going back to your point about, well, they're asserting that the 2020 inspection report is when we found out. Well, there's no affidavit in the record saying nothing happened between 2012 and 2020 to make us get this.
So the performance issues you're referring to is we did the work for you guys in 2009, ended in 2009, and we didn't do very good work. So we came back in 2011 to fix our bad work here. And so you guys should be on notice that when we come and do work for you guys, it might not be very good. And well, I know that's somewhat tongue in cheek, but I mean, what are they on notice of once you fix everything at your own proactive initiation and not their request?
They're on notice that there were performance issues with the building envelope. And what they're now suing over was a part of the building envelope. And if there's a reason that they decided to sue on this in 2020, besides they woke up one morning and asked for an inspection, they have the burden to tell us that. Remember, Judge, that the new summary judgment standard requires more than the slightest doubt about facts or the mere scintilla of evidence. You have to present your evidence as you would to a jury. And if your evidence does not establish your burden, then you lose. And that's what's going on here with Aiken Park.
If you want to, from historical, I was on the panel that teed it up for the Supreme Court to change the rule. I was the guy who was the mover of that case, so you can thank me or condemn me for the summary judgment rule.
I'll thank you for this case.
Yeah, I know.
That will-
Maybe you might not like how it's turning out with you here with me, but.
Counselor, let me ask you this. If suppose that in 2011, D.R. Horton said, the problem with the stucco is that water is getting in through the stucco barrier itself and through the house wrap and getting into the wood framing and causing problems. So we're going to replace it. And you do that, or Horton does that. But after the repair, the stucco works fine, but it's the seal with the wind around the windows and such water coming in there. In other words, by repairing one problem, create another one. Would we still be in the same place if that had happened here? Would anything change about your position with respect to 9511?
I think that would arguably be a new latent defect, but Beacon Park would have to come to us and say, water started leaking in around the windows on a certain date. And we exercise due diligence to inspect why that was happening. And that is what we're missing here. They have refused to tell us why they ordered that inspection. The only evidence in the record is performance issues, water intrusion on an unnamed date. That means there's no question for a jury and this court should affirm.
Thank you.
Thank you.
You probably want me to go back to the 50 CA.
I just want to touch on a couple of points. Your Honor asked opposing counsel if the allegations had been limited to the new work, would that make any difference? And the answer was no, it wouldn't, because the new work was a repair. There's no difference between, there's no such thing as new work under the statute.
Counsel, what about the language in the statute 9511 that refers to correction of defects to completed work or repair of completed work? You've talked about how, repair might mean one thing in two different contexts, but isn't it, if there was a defect in the stucco and D.R. Horton replaced all of it, isn't that the correction of a defect under the language of the statute?
That's a part of the statute, but the other part of the statute is completed work. So I think that contemplates a situation where you have a 2009 old stucco, and let's say there's a leak, and they come back under the same permit, because the permit is part of the statute as well, and they repair something within that stucco. They patch it, or let's say it's a roof, they replace a shingle. No new permits are required. They've corrected a defect to that completed work. The completed work remains on the site. The permits are the same. It's a repair that does not extend the statute of limitations for latent defects within that completed work. But that's not the universe that we're in. The universe that we're in is that all the completed work was removed. The completed work no longer exists. It was entirely replaced with new work. And as you pointed out, the defects are, we have no idea what the 2009 defects were. We have no idea what the performance issues were.
Well, they're gone.
They're gone. And they did not say that there were performance issues with the building envelope. They said there were performance issues with the stucco. They removed all of the stucco.
But they
Again,
replaced the entire envelope, didn't they?
they replaced the stucco portion of the envelope. There was a portion of the house that had, or the houses that had siding. So I think it's really akin to a new roof. And then the question becomes, if you replace a new roof, if you replace an old roof with a new roof down to the flashing, under what they've said today and what the trial court held, that is just a repair to a completed construction. And the installation of the new roof itself puts you on notice that there may be defects, problems in the building envelope. And so that means as soon as anybody gets a new roof, they better have it, inspected every 6 months for the possibility of latent defects, because once 4 years goes by, you're out of luck. And you better hope that your house isn't more than 10 years old, because by the time the new roof is installed, statute of repose is already run.
What if to take your analogy a little, maybe make it a little different, I think closer to this case, what if they replace half a roof?
I think the difference here is that, and that's a very good question. I think the difference here is that there are two different siding systems in the house, or in the houses. There was the stucco that covered the entire second story floor, and there was siding that covered the first floors. So they use completely different systems, completely different contractors. But I think it's more akin to what would happen if you had slate roof on your garage and you had shingles on your house, and you replaced all the shingles on your house pursuant to a permit and didn't touch the garage. We would argue that the statute of limitations would start running from the installation of that new roof, just like it starts running from the installation of the stucco in this case. On the burden of proof issue, if this court is considering a tipsy coachman affirmance, which we don't think that it should, because we believe we didn't have the burden and that we've met the burden. But if it is considering it, we think because the issue was not really factually litigated below about whether or not the evidence in 2020 was sufficient, we think the proper remedy would be for a remand to allow that issue to be litigated. We request this court to reverse and remand for further proceedings. Thank you.
Thank you.
Good arguments. Good job, Stan.
Yes.